And the reason I think we need more discussion on this is to bring back the emphasis that social historians like Edmund Morgan in his American Slavery, American Freedom in 1975, where he pointed out the great paradox of America was how we had slavery and freedom instituted at the same time. And we wrestled that, we really struggled with that for so long in our history, and it took us up to the Civil Rights Acts of the 60s to really fully wrestle with that in a constitutional legal way. And there's a very long history to that, and that's why I emphasize that the Constitution is a living kind of document, not just what was in 1787. And I just wanted to close by just showing a broadsheet from the preamble, because we all respond to the preamble, the we the people. And if you look at how it was printed when it was first ratified, you can see how James Wilson, who authored this, he's a conservative lawyer in Philadelphia, one of the first members of the Supreme Court, the original 6. You can see how when it was published for distribution, they took that preamble and blew it up. What was our aims? What was the goals of the Constitution? It's just kind of interesting for students in a context to recall how it might have been read at the time. And not all the detail of the Constitution, the articles establishment, the branches are small type. But what I think for students, is a problem and why we look at social history this way. If you looked at the changes in that preamble in the month before, there are a number of interesting changes and negotiations taking place. So it was a document of compromise, the emphasis on the preamble. It starts off, we the people, the states, etc. Whereas he's changed it a month later to we the people of the United States. And then he inserts all the philosophy of the Constitution. Establish justice, so forth, tranquility, general welfare. There's quite a bit of negotiation that was taking place. And I think that's a rich area. That's just something that I think comes from the social history side. We're interested in why all these changes and negotiations, how Shays' Rebellion, the tax revolts in the winter before the revolution, the Constitution conventions took place, how that shaped the forming of the Constitution, these kinds of crises. And so this is probably where social historians, I think, legal historians have a degree of difference, is where they emphasize slavery or Shays' Rebellion, tax revolts. And I should say that the author of the preamble ended up in debtor's prison. So these ideas of mortgage, debt crisis, creditor crisis, was with us then. Another angle I should mention, just for students to take, just to close, is comparative constitutions. How is our, we're talking about the durability of our Constitution, which is unique for its durability, but looking at it comparatively, you can look at Canada, the Act of Dominion in 1867, they completely overhauled their Constitution in 1982. Mexico has had numerous reiterations, the last time in the Revolution in 1917. The idea of rewriting constitutions has happened. I'm not endorsing we're doing that, but it's interesting as a problem for students to look at how other constitutions form. If you look at the European Constitution, the proposal is 400 pages. And think about that. Ours is about, 18 pages here? And it's a 400-page document, and it's, maybe that's no wonder it can't get codified. Just try to read through it, it's pretty hard. So,
thank you, Dr. King. The next portion of the panel, I'd like the panelists, embedded in your comments may have been some fighting words. And I want to take a few minutes to see if you want to, among yourselves, tease anything out that you'd like to wrestle with there for a minute. And then after that, we'll turn time over to the audience to have a conversation with the panel.
Well, let me challenge the idea that there's an imperial presidency, which an unresponsive judiciary lets run free. Okay, that means I'm a Democrat. I've never voted for George Bush, but the United States Supreme Court at the moment is pretty much dominated by conservatives, nominated by Republicans. Nonetheless, Bush's efforts and the administration's efforts to detain people in Guantanamo has been slapped down again and again and again by otherwise conservative justices. I see that as an example of the checks and balances working. You have people who probably my guess is that Anton Scalia and Joseph Alito probably agree in principle with whatever it is that they're doing in Guantanamo, but they recognize that it is unconstitutional. And to me, I'm surprised that there hasn't been more discussion of that, because you have a presidency that I think it's referred to as the Cheney's version of the unitary presidency, the idea that the president has almost unlimited powers. And this is extended, obviously. Guantanamo was picked for a reason. I don't know if most people understand that. The idea is it's neither a foreign country nor the United States. So basically you can do anything you want there. And what the Supreme Court said is really pretty amazing, which is, no, you can't. You have to give people certain rights, and you can't do this. And they don't like it, but they follow it.
Would anybody disagree with that?
Well, I think a lot of the pressure behind moving toward that, there's a lot of big law firms volunteer a lot of time too to take these cases up. And I mean, a lot of them, I've got colleagues who've given time and testifying in these cases. And it took a lot of people willing to give a lot of time and donate time and pushing these cases forward.
But these justices, I mean, they're appointed for life. I mean, yeah, well, Anthony Scalia doesn't do anything he doesn't want to.
Yeah, but he's hit or miss on that. I mean, he's going to, you're not going to change him. Yeah, his reading of that might have been.
Is that a constitutional problem?
Yeah. No, I don't think. But I don't think it would have come to the Supreme Court without the pressure of these forces bringing it forward.
Well, I think the constitutional issue is the appointed for life business. Is that a wise constitutional provision?
For the federal Supreme Court, I think it is. And federal judges, for example, even trial judges are appointed for life. It's radically different. The vast majority of state judges are elected for usually longer periods of time. In Oregon, it's 6 years. But you have example after example in the federal judiciary of people that are appointed by a president that they think are going to turn out one way and basically vote their conscience, which then often consternates the president. Now you can get some real ringers. You can get some incredibly brilliant, remarkable people. Earl Warren, who was one of the most, quote, liberal justices of the United States Supreme Court, was the district attorney of Oakland and the attorney general of California and the governor of California. He was a person who was a Republican who was put in by Eisenhower to basically keep him from running for president. And Warren ended up leading a court that created an enormous number of civil liberties. So
I think today you have these very hard ideologies, and there's a hard ideology, very much a hard, ideology. The conservatives today are way more conservative than Earl Warren. Earl Warren would be a liberal by today's standards. Eisenhower would be a liberal by today's standards in terms of where conservatism has gone. And you have groups of people like this so-called Federalist Society, which is a society of very conservative Republicans who want to completely remake the court, remake the whole notion of property law. And the court has really become something of a political football. It was supposed to be, one of the reasons that people were appointed for life is that it was kind of supposed to be something sort of above politics. It was supposed to be less dominated by the politics of the moment and having to get elected and doing electioneering and so on. And so it was supposed to be more impartial, but in fact, the court has become unbelievably partial. And to me, the most extreme example of that was the Bush versus Gore case, in which the court actually chose the president, stopped a legitimate recount, and chose the president. And the interesting thing is that the 5 people who participated in that, all conservative Republicans, who chose Bush. The thing that's interesting about that is that the court lost my train of thought on that one.
Well, does it matter in the case of this? The Supreme Court stepped in and basically said no more counting. We're making it. We're going to overturn the Florida Supreme Court. But when newspapers hired, and again, I definitely did not vote for George Bush in 2000, and he didn't win the popular vote. He won I see a Republican back there.